I'm Laurel Price. We're here today to interview Bob Langer. Bob, let's begin today with just a basic question. Where did you grow up and what was your education?
I grew up in Norwalk, Connecticut. I went to college at Franklin and Marshall College in Lancaster, Pennsylvania. I was a government and philosophy major. And then went to the University of Connecticut School of Law, graduating in 1973.
Now, you started with the Connecticut AG's office working in the Antitrust unit in 1973. Was that straight out of law school?
That's correct. I had interned in the Attorney General's office my senior year as part of a clinic program. And in order to be hired by the Attorney General's office, they had oral competitive examinations, which for every level, actually. And I was fortunate to be hired in a time, as you know as well, there weren't an awful lot of jobs around in the early 70s, and started in September 1973.
How many people were in the unit at that time?
I don't think it was really a unit. It had started, so there was my supervisor, who was actually doing construction, sort of contract litigation, a guy named Rod Dowling, who's unfortunately since passed away, and me. And sometime, as far as I recall, sometime at the beginning of '74, they hired a third attorney, a guy named John McKenna, who came out of private practice, and John and I got to be great friends, and even to this day continue to team teach a course together for the last almost 30 years. But it was basically, we started with one person. I came in, and then we had three people for a couple of years and finally added a fourth.
And did you do both the investigation and the litigation, or did you have separate investigators?
At that point, we had no separate investigators. We had subpoena power and did our own investigations, but the bulk of what we did was a single case for the time that, not exclusively, but almost exclusively, from 1973 to the time I left to become head of consumer protection in '76, we began what was called State of Connecticut versus Amarada Hess, which later became Petroleum Products Antitrust Litigation, MDL 150, and most of my time was spent litigating that particular matter.
Well, I was going to get around to that a little later, but
Sure.
since you brought it up,
Well,
let's deal with it now. How many states actually got involved in MDL 150?
Well, when we started, it was Connecticut and Florida. And Florida had private counsel, and we were the Attorney General's office. We had our own people. Kansas joined, but my recollection is they dropped out within a year or two. And then I think in either '75 or '76, at the time the case was eventually transferred to the Central District of California from Connecticut, most of the western states joined. I think it was, certainly Washington, California, Arizona. So I think there ended up with 5 western states plus us, and then Kansas dropped out, Florida stayed in, and then we dropped out in 1980 after settling out, and that case continued, as you may recall.
How long did it go on?
I always use this as a lesson in be careful what you wish for. The case it concerned the alleged destruction of the independent sector of the oil industry and was a follow-on to the Exxon litigation brought by the Federal Trade Commission. The case started in '73. We ended the case in 1980. My recollection is the last defendant settled with the last plaintiff in 1992. And so there were several folks who had their entire legal career up to that point with a single case with an awful lot of paper.
At the time you started, how active was NAG in the antitrust area?
My impression was, of course, I was not a supervisor when I first started, that NAG was primarily located, they had an office in DC and they had a base of operation in North Carolina. And it really wasn't, NAG was not an organizing entity for antitrust at all. There were collaborations which began with MDL 150 on the antitrust side, although as we know there were earlier proprietary cases brought by the states through private counsel mostly, although there were probably exceptions with New Jersey, but private counsel in other actions such as tetracycline in the late 60s and early 70s. But I didn't think NAG was a vehicle at that point, and I think there was a later event prior to the task force that actually triggered much of this, which I'd be happy to talk about.
Was MDL 150 the first case that Connecticut did on a national scope using in-house counsel?
Yes. Up until then, all of the cases, softwood, plywood, sugar, armored car, tetracycline, were all done through contracts that the Attorney General at that time entered into with private lawyers.
And I seem to recall he had a contract with a private lawyer to bring what became In re Chicken antitrust litigation, and Connecticut was actually, I think, the national class representative.
And that, and I think there were a couple of others back then where Connecticut was the national class rep. That's correct. And when I came in eventually and later on, and as head of both antitrust and consumer protection, I helped to manage some of that, and then those cases eventually, as you know, ended.
Were you involved at all in the early days of what was known as ESALC, the Eastern States Action Litigation Committee?
I had a small part. I was more active in the Eastern States Antitrust Committee than I was in ESALC. I think there was a transition period when I had moved out of antitrust in 1976, when then Attorney General Agello asked me to take over the new Consumer Protection Unit, which then became a department.
Okay, but you were involved in ESAC before you went over to do consumer.
Yes, for a short period of time.
ESAC stands for the Eastern States Antitrust Committee. Could you just give us a little bit of background on what they were doing at that point?
Well, there was an aggressive group of Eastern State antitrust departments that before NAG, before the National Association of Attorneys General, got together in a more meaningful way to help organize antitrust enforcement, and several of us, you and me and some folks in the states, really from Maine, my recollection is down to Virginia.
And I think as far west as Ohio.
At some point Ohio joined. We considered them part of the East apparently in that time. And so we brought some cases that had not been brought by the federal government, coordinated with ourselves on an informal basis. Some cases were brought, my recollection is one of them, we brought an individual, and you probably remember this in fact better than I do, brought one of those cases in separate state courts to really drive the defendants completely mad, and other cases like art materials I thought we brought in federal court.
Yeah, you're probably referring to copper water tubing.
Copper water tubing.
Part of that was brought in the Eastern District of New York, and then there were 4 or 5 separate state court cases.
Right. That's correct.
So they were basically doing cooperative litigation on a regional basis during that time period.
That's correct, right.
How would you characterize federal-state cooperation during that time period?
Prior to the time that I started, I thought there was cooperation by the feds, but there wasn't a great deal of respect. That is, that we were considered to be a stepchild during the 70s. And of course there was from 76 to 80, I was really out of antitrust for a while on a direct basis. So when I got back in, and the new administration took place after the Carter administration had ended, there were some real problems, I thought, with coordination, cooperation, and communication, really the 3 C's, with the federal. Now, we had less problem, I thought, because we had a really good, I thought our office had a very good relationship with the New York office of the Antitrust Division. We had no criminal powers. So we would often refer really good cases where there was horizontal price fixing to the feds. And so on a regional basis, I thought we got along just fine. In terms of national policy, during the Reagan administration, there clearly was problems in terms of how we got along with each other, and it manifested itself in innumerable ways, including, as we know, different policy statements regarding mergers and vertical restraints.
Had Hart-Scott-Rodino passed before you went over to the consumer unit, or did that happen after you moved?
I moved in March of '76, and Hart-Scott was, my recollection was the end of '74, somewhere in '75.
Okay.
So just about the same time.
And had the grant program actually started?
The grant program started after I left to go to consumer protection, and then I was the beneficiary of that when I returned to antitrust in 1980.
Okay, but you were still around in '75 when the fair trade laws were repealed.
That Consumer Goods Pricing Act comes in, and the end of the fair trade laws was before I moved on to consumer. That's
Okay.
correct.
So in '76, you moved over to the consumer unit. How would you compare the two operations in terms of the way they were organized and operated?
I mean, on an intrastate basis, or
Yes, just internally.
we had on the antitrust side an apparatus to go to federal court and to coordinate because of the fact that states had standing under the federal antitrust laws. When I took over consumer protection, there was no law. We used the State Antitrust Act at that time simply for state investigations and using our subpoena power. The difference is that at the consumer side, there was no federal cause of action available because the FTC Act didn't provide for standing of anybody other than the FTC, and there was no law, which means that I was tasked with the idea, with the job of simply creating the law and starting enforcement of consumer protection within the state. And eventually, within a year or so, a case comes along that allows for interstate coordination of consumer protection that had never existed before. But it was a very different vehicle because it was all, at that point, it was all state law, and we did much less coordination with the FTC on the consumer side, of course, than we did even with either the FTC or the Department of Justice on the antitrust side.
Okay. Now, if I understood you, you didn't even have a consumer protection statute when you started?
The statute was in place in '70. The antitrust statute was adopted in '71. The Unfair Trade Practices Act was adopted in '73, but nothing had been done with it. It needed an amendment, a series of amendments which I drafted that then were able to be used by the state and by private parties to actually create a little FTC Act that had some teeth in it.
Okay. Now, and this is my personal observation, I saw some states that tried to operate consumer complaint bureaus with their consumer operations, and other that tried to follow a more complaint-based law enforcement type operation. Which of those models would you say characterize?
We started on a basis where we were primarily an enforcer. And remember, in Connecticut, we had a Department of Consumer Protection, which was the principal administrator of our consumer protection law. The Attorney General only had derivative powers in consumer protection and had direct authority in antitrust. So all of the complaints would go through the Department of Consumer Protection. Eventually, particularly when Joe Lieberman became Attorney General in '83, and then certainly as it moved on to, particularly to Dick Blumenthal in '91, the Attorney General used his consumer protection, indirect consumer protection powers in a different way to actually create a consumer complaint bureau and reach out to consumers that was not just adjudicative and enforcement and focus.
So actually trying to mediate specific consumer complaints.
And actually, in some ways, arm wrestle the Consumer Protection Commissioner over who had primary responsibility for consumer protection with our state, which always created some interesting challenges for me because I was always in the middle of that.
You just indicated that there was a case that came along that created the first opportunity for multi-state cooperation in consumer protection. I assume you're talking about the GE engine switch case.
Chevy Mobile litigation.
Could you just tell us a little bit about that and
Sure.
how that was coordinated?
The matter came about in 1977, and many states had gotten complaints that General Motors, as a result of shortage of certain Oldsmobile engines, had substituted Chevrolet engines in 1977 Oldsmobiles. It turned out to be 77 Oldsmobiles, Buicks, and Pontiacs. So it was a material non-disclosure case. Would consumers have purchased the product because Oldsmobile in particular had marketed its Rocket 88 engine as being better than other engines. And quite frankly, in all the years I've done antitrust and consumer protection, the angriest consumers I ever dealt with were Oldsmobile owners that bought a Chevy engine or had an Oldsmobile with a Chevy engine. So as a result of that, Bill Brown, the Attorney General of Ohio, was the chair of the Consumer Protection Committee. I think he's since deceased. And he was a central figure in organizing the states into a group for the first time that I knew of on a national basis. We eventually, to make a long story short, created a national negotiating team of about 15 or 17 of us, many of us only a couple of years out of law school. General Motors had hired Jones Day, Pat McCartan, and eventually there was a Magnuson Moss case at the same time. But the principal vehicle for negotiation was a group of states. Eventually, every state in the country joined in, although California had its own way of doing things back then and still does today, as did New York. But all the states, and eventually Canada we negotiated for the first time at the end of, it was December 77. It was in San Francisco. The interesting thing about that is at that time was I was involved with getting the settlement agreement done, in which there was eventually about a $40 to $50 million cash settlement to consumers in the country and various other remedies, which we thought, by the way, back then was a lot of money. Is if you look back at that time in history, who were the attorneys general we were dealing with? You had Louis Lefkowitz was still Attorney General of New York. And this guy named, I'm not sure you've heard of him since, but a guy named Bill Clinton was the Attorney General of Arkansas. He looked like he was about 11 years old back then, by the way.
And Frank Kelly was probably still in Michigan.
Frank Kelly and Billy Gust, whose family had owned Antoine's, was the Attorney General of Louisiana. And Bruce Babbitt, who later became Interior Secretary under Clinton, was the Attorney General of Arizona. And this guy, again, you probably wouldn't have heard of him, David Souter, was the Attorney General of New Hampshire. So we were dealing with all these people who later on in their life had obviously decided to do something other than being Attorney General. But I think the importance of that case was, and I mentioned this to you, and I've mentioned it to every Attorney General I've ever known, because every time an Attorney General becomes Attorney General and he or she decides that they have now invented a multi-state enforcement, diplomatically, I can now scan in and email to them this op-ed piece that I wrote in the New York Times in the beginning of 1978 saying, here's where it started. And Bill Brown and the folks at, and it was the first time really that the National Association of Attorneys General put its imprimatur behind a multi-state consumer protection matter. I think that had some effect upon what eventually became the NAG Multi-State Antitrust Task Force, because we proved it could work. And the problem, as you well know from what you did and what I did at the time, is dealing with the states is often comparable to herding cats, because every state is sovereign, every attorney general, most of them were elected, and the only way you could get states to work together was to persuade them to work together. There was no vehicle that allowed you to actually force people to work together. So, but as a result of the Chevy Mobile settlement and its success in terms of creating a model for cooperative state enforcement, I think that led to some very significant developments later on in the 80s and 90s.
Now, on the antitrust side, when we would negotiate a national settlement, we would pick a appropriate federal district court and we'd docket it, get the approvals. Since every state had to do this under their separate state laws, how did you implement the settlement?
There was a national class action brought in the Northern District of Illinois under the Magnuson-Moss Act, and we conveniently, brilliantly, luckily used the vehicle of the national class settlement to resolve both the state and federal cases in order to buy peace and be able to have a vehicle, no pun intended, or I guess pun intended, to distribute the money.
Out of that experience, was more cooperative type enforcement undertaken on the consumer side?
I thought it was a long time from the time of the Chevy Mobile settlement to the creation of, which we've never had on the consumer side, the type of formal structure that was eventually created through the multi-state antitrust task force of NAG. So it's always been a more ad hoc multi-state working group in which one state takes the lead as opposed to another. But I think it was the predecessor to it. By the time I left government in '94, there was a group of, I thought, more experienced and mature consumer protection enforcers. I thought one of the, why that's important, there was a real difference in my view between the folks that were doing consumer protection for the most part in the 70s and 80s as opposed to antitrust. Many of us on the antitrust side had been there a while, were pretty experienced litigators. Many of us were civil servants, and we were in it for the long haul and had a wealth of experience to rely on. On the consumer side, there was significantly more turnover. There was also a more hands-on, and that's a neutral term, micromanagement by state attorneys general on the consumer side, because they, many of those state AGs thought they understood consumer protection and frankly deferred to folks like you and me on the antitrust side because they thought it was
hard to understand,
more complicated. and there was a great deal of deference accorded to us, I think, during your tenure, during my tenure, that was lost at some point along the way on the antitrust side and probably never existed on the consumer protection side at all.
Okay. In 1980, you become head of both the antitrust and consumer protection units. How did you bring those two units together and make them work?
We ended up with probably 10 or 12 people apart from, in terms of attorneys. What I tried to do was make sure that every consumer protection person knew something about antitrust, that every consumer protection person knew something about, every antitrust person knew something about consumer protection. Eventually, folks gravitated towards their strength. And so while I had a combined department and I was the central, of course I did both, so it was very convenient for me to be the sort of the centerpiece for all of this information to flow from me through, usually directly to the Attorney General. There was very little in the way of bureaucratic bureaucracy at all. I mean, we did have a Deputy Attorney General who was extremely able, but many of the matters we worked on, because of the nature of what we did, it was sort of everything was front page back then, the Attorney General would be of some interest. But it was a real challenge, because I think we were one of the first states. I don't think we were the first state, because I think Washington may have been comparable to that. But we were one of the first states that combined their antitrust and consumer protection functions within a single department with a single person who had responsibility for both.
I think Steve Wessler in Maine may have had.
Yeah, but he had a much smaller unit to work with. But I think you're absolutely right about that.
How did it work out? Did the merger benefit both missions?
Initially, I thought it was a really good idea. And eventually what happened, in my view, is that consumer protection tended to swallow up antitrust. Consumer protection would get more resources. And there were, for every antitrust matter, we would have 10 or 12 or 15 consumer protection matters. That's sort of the nature of the beast. And I thought by the time that I left, that consumer protection had grown more, and if it were up to me, which it wasn't at the time, I would have separated the units back out, and indeed, that's exactly what happened in Connecticut. Eventually, after I left, they went back to the old system of a separate antitrust and consumer protection department. I think at the time, though, they needed someone who had experience and who knew both areas. And frankly, I was, I just happened to be in the right place at the right time. It was just a very fortunate situation for me, and an unfortunate situation for some other folks, I think, perhaps, including some of the defendants.
Okay, now, 1980, you come in, you take over antitrust, being in charge now, and 4 years have gone by. What had changed on the national scene, especially at NAG, during those intervening 4 years?
It's not clear to me that as of 1980 there was a lot of change. I think there, the Eastern States Antitrust Committee on the regional level, I think it was a couple of, my recollection at least, and frankly, you may actually remember more of this than I do, in which case you ought to be answering some of these questions, not me. But my recollection is it was a couple of years later that we did have national training seminars that began probably in the late 70s, even while I was still doing consumer protection. That had enormous value in educating consumers. We did have a couple of cases. I remember Cuisinarts was 81.
Yeah, because that was brought when.
Right. Right.
I'm
Okay. So
fluffing on
the
the
point
name,
of Cuisinarts was we were looking at the last criminal prosecution brought by the Justice Department for vertical price fixing. And we decided we were going to do something about it as well. And in order to do that, we wanted to get access to the grand jury materials that were the basis for the Cuisinarts matter. And somehow or another, I got the assignment to argue the case in the Second Circuit as to whether or not states had access to grand jury materials without having to go through that is, we had special access to it under I think it was 4FB
Yeah, the argument, as I recall it, was when Section 4FB of the Hart-Scott-Rodino Act required the Attorney General to cooperate and provide notice to state attorneys general and to provide information relative to violations.
And did it exclude grand jury materials or include them? That's right.
Well, they took the position, as I recall, that it included them, but that a separate application had to be made under Criminal Rule 6E for access.
That's correct. And so we ended up, I think there were 4 different suits brought to seek access to grand jury materials at the time in 4 different circuits. I know there was one in the 4th Circuit, one in the 9th Circuit, and one in the 7th Circuit, which is the one that eventually got to the U.S. Supreme Court first. One of the great disappointments in my career is I would say it was Illinois versus Abbott.
Right.
And maybe that was fortunate because my recollection is that the Supreme Court ruled 9-0 that state attorneys general did not have access under 6E to grand jury materials. And so maybe it was best that I not be sacrificed in that particular case. But the point is that was another situation back in the just in the beginning of the early 80s, where the states and the federal government had a different point of view, where the states got together thinking that we should be able to get prosecute because we were the vertical price fixing people, at least we thought we were, and that has never changed. I mean, the only way around that problem is when those states were assistant attorney general from a particular state was assigned to the Justice Department, but then they couldn't use that information back going the other direction at the state level.
Now, the piece of the Illinois Abbott puzzle that you may not know is that the case ultimately turned on the phrase otherwise permitted by law.
Right.
And that was a last-minute cloakroom insertion into the statute that was consented to by NAG just to get it passed. And we said we'd sort it out later in the courts.
Yeah, I guess I was sacrificed then in the Cuisinarts case, but.
In the Reagan administration arrives, and things changed. The whole tone of Washington as relates to antitrust changes. I recall the first budget message OMB sent up defunded the Federal Trade Commission from antitrust enforcement. Mm-hmm. How did the states react to that?
Well, initially I think we were slow to react. That was my recollection, but eventually there was, I think, several of us who had been around a while, whether we convinced our bosses or whether our elected or appointed officials on their own came to the same conclusion that there was a void that needed to be filled, that there were matters that were not being dealt with. And by, I would think, 83, I'm not sure it started as early as 81, 82, but certainly by the time of 85 in particular, I recall because there was Texaco Getty, and the real arguments about access to Hart-Scott-Rodino materials, where we had a real food fight with the Federal Trade Commission and the Department of Justice over access to Hart-Scott-Rodino materials, which eventually resulted in Maddox versus FTC and Lieberman versus FTC in the Second Circuit, which again, I was privileged to argue. I think you were actually physically present.
I was indeed.
And you saw me.
And we're going to come back to those two in a minute, but first I want to focus your attention on what I think may have been the biggest triggering moment in the deterioration of federal-state relationships. The briefs in Monsanto.
Oh, okay. Well.
And basically the Justice Department submitted a brief saying resale price maintenance should be rule of reason. The states submitted a brief saying per se, and before oral argument, as I recall, Justice limited the DOJ budget to preclude arguing for the per se position.
I think Congress
right
imposed upon a restriction upon the Solicitor General so that their brief could not argue for the rule.
The brief did. It was oral argument that
it was in the brief? Okay.
Yeah, it was in the brief.
That's why it's useful that you're doing this interview, because you remember things that I don't remember.
But
we're not getting any older either. So.
No. Right. The House, I think it was the House Ways and Means Committee, put a provision into the Justice budget saying they could not advocate it.
That's correct, right.
And Baxter was left standing there unable to argue that portion of the brief.
That's correct. That was one of the... There was another event where I think you and I were present, which didn't help things, when there was a real dispute between the late Bill Baxter and the first chair of the task force, Lloyd Constantine.
Oh, the Harvard conference.
At Harvard, where they really got into a major league argument that ended badly, and I don't think helped those relations at all between the Department of Justice, Antitrust Division, and the states. But Bill had taken the position, my recollection is, that in national matters, the states had no role. And what role we had was done badly because the people weren't very good. And the combination of those messages, which is you're either incompetent or you're doing things that we should be doing, at a time when we thought we actually were pretty good at what we did and we were filling a void created by a vacuum, I thought joined issue quite well with certainly in the first Reagan administration.
Yes, I recollect that meeting. I think Baxter was making the point that the Justice Department was going to intervene in private cases and articulate for more lenient treatment of vertical restraints. And I think the precise question Lloyd asked was, how do you reconcile that with your duty as a prosecutor? May you recall his answer?
I don't recall his answer, not specifically.
My recollection is he said, well, I don't consider myself a prosecutor. I consider myself the chief advocate for competition in the United States.
So I think I'd probably block out some of the...
In time, the relationship thawed. What happened to cause the federal-state relationship to improve?
And that's where I think you and I and a few others come into the picture. The Bush administration and
the first Bush administration.
Yes, that's right. George Herbert Walker Bush appointed two people to positions of authority, the late Janet Steiger as chairman of the FTC and Jim Rill as the head of the Antitrust Division. And it was quite clear from the beginning that part of their mission was to thaw the relationship. And it went in two directions. I mean, one of the things that happened when I became chair of the task force, and as you well know, by then we had created an executive working group, which was a group of, my recollection is either 4 or 5 attorneys general. I think back then it was Bob Abrams and Paul Van Dam and my boss, Dick Blumenthal, and a couple other folks, and the head of the Antitrust Division and the head of the Federal Trade Commission, and some of the other commissioners would show up. And it was at those private meetings that with a real attempt to try to work together to find areas of collaboration. And with all due respect to others, I thought, and I've said this for many, many, many years, that the most important person in that dynamic was Janet Steiger. There is no question in my mind that it was her personality and her drive. I mean, Jim Rill was certainly helpful, although we had some interesting issues, as you recall, with the 92 horizontal merger guidelines when they were being announced. But Janet and her people, and I mean that the Director of the Bureau of Competition, Kevin Arquette, and the Director of the Bureau of Consumer Protection, Barry Cutler, are, I think, the key people that thawed that relationship, which continues to exist today.
I think the moment we knew it was going to change was shortly after Jim Rill got to justice. He called Lloyd Constantine up and asked him to delay the filing of the cable case so that Justice could get up to speed and join us. I want to direct your attention to a cartoon that appeared in the Hartford Courant sometime late in March 1988. Shows Joe Lieberman in bed with the insurance industry. What was that about?
One of the most important developments in the NAG Antitrust Task Force, and it's a matter that could have very well destroyed the task force that you and I can talk about, and we probably will, is there was an investigation by several states. That the investigation was not undertaken by Connecticut. We certainly were not involved with this, and I'm not sure I even knew about it at the time. And the claim concerned the switch by certain parts of the insurance industry, domestic and foreign, from occurrence-based to claims-made insurance for commercial general liability insurance throughout the North American property casualty market. What happened is many of the states then filed this lawsuit, and I think New Jersey was in the first wave?
No.
You were not?
No, there were 8 states in the first wave, and Texas filed in state court.
Okay, so we were not part of the first wave. And because Connecticut is the quote-unquote, or at least at the time was the insurance state, there was enormous criticism in our state and around the country, but certainly in our state, as to whether or not Joe Lieberman, who was then the elected Attorney General of our state, was shortly thereafter ran for the U.S. Senate and beat then Senator Lowell Weicker, was cozying up or had cozied up to the insurance industry. He suffered tremendous criticism over that. What I knew at the time as the head of antitrust was we weren't in the equation because some other states, including perhaps California and others, for whatever reason, and I'm not sure to this day exactly what it is, or at least I'm not willing to speculate while the camera is focused on me. And as a result, Engelhardt, who is the political cartoonist for the Hartford Courant, wrote, I thought was one of the most brilliant political cartoons I'd ever seen, where Joe is holding the Traveler's umbrella. Travelers was not involved in the matter, however, on a bed that had an Aetna logo and lying in bed next to the Hartford Stag, which I thought has multiple interpretations to it. I'm not sure animal husbandry was one of them, but Joe was not happy, let me say that. And the next thing that happened was he ordered Clarine Hardy-Riddle, then Deputy Attorney General, later to become the Attorney General after he became a senator, and me, to organize our group to investigate the allegations. And we then became a second wave of litigation that filed against the domestic insurers, reinsurers, and the Lloyd's of London insurers. And that was a very difficult time for our office.
How did the states reconcile that?
Well, there were some serious personality issues at the time in the terms of the structure of the insurance litigation. And I think one of the ways this matter was resolved was the particular fellow in California who took over and became our liaison counsel, Tom Green. I've said before, and I'll say today, that I think if it weren't for Tom, I'm not sure the task force would have survived the insurance case. And we owe a great debt of gratitude to Tom for the work he did on that because of his personality and his presence. we eventually, with the first and second waves, became a single force. As you've referred to it as a virtual legal office. That was the earliest time when we were emailing around in the late 80s, early 90s, editing each other's briefs when even law firms weren't doing that. And Tom, I think, deserves a great deal of credit for his way of managing that litigation at an early stage. Later on, we all took on our responsibilities, you most importantly, in terms of arguing before the Ninth Circuit and before the U.S. Supreme Court, and making law that is maybe the single most important McCarran-Ferguson case in the history of this country. So.
Well, I don't want you to denigrate your own contributions to the task force, because one of the things you brought to the process was an abiding sense of humor. And I just wonder whether all of the Groucho Marx paraphernalia you used to keep in your office in the Connecticut AG's office made it into your current practice.
I stopped doing that at the office because I was fearful some of my partners would think I was reasonably weird. I used to dress up as Groucho and scare children at Halloween, and my wife convinced me to stop doing that as well, because they thought they would take me away at some point. But I thought what we did, I think you're as responsible as I am, from the time that Mike left, because he was only there about a year. I thought that you could have been the next chair. It turns out I was appointed by Attorney General Shannon, but then you took over for 3 years, and then Kevin O'Connor and Tom Green. And I think that combination, because we were different personalities than Lloyd. Lloyd performed an enormously important function. He was extremely confrontational at a time when confrontation was needed. I think at the time that I took over, we needed someone who could work with Janet and Jim and Kevin and Barry. And then you took it on, that responsibility, from 92 to 95. And I think we're all, the better for the fact that we were in the right position historically at the right time.
What would you think was the most important aspect of your contribution to the task force?
I thought it was the inclusiveness of bringing in more people into the leadership. I thought that we started with a good idea, but I think we created regional vice chairs. We encouraged the heads of those departments to become integrated into what we did as enforcers. And I thought the regional vice chairs, the proliferation of the number of national vice chairs, gave everybody a stake so that they could go to their attorney general and say, this is important for our state. And I don't think it would have, if we stayed as small and as parochial and as ad hoc as it started out, it never would have survived.
You've now had 13 years in private practice. Looking back, do you still think there's a substantial role for the states in national antitrust enforcement?
Yes, I do. Some of my views regarding substantive antitrust have changed. I certainly have changed my views a bit on vertical restraints from the rabid vertical price-fixing enforcer I was during the 80s and 90s. But in terms of having a separate voice, I came up with the term, the third prong and the antitrust triad, and we were RPM central and all of those little catchy phrases. I do think that the states perform an enormously valuable role. I sometimes don't agree with some of their economic analysis, but then I often don't agree with the Department of Justice or FTC, and that may be more a function of the role I play as counselor and defense lawyer these days. I do some plaintiff's work, but I do think that my current experience has, whether it's educated me, modified me, or the like, I've changed a bit. But I think the states are absolutely invaluable. And as I've said, and you've written articles, I've written articles, people need to understand that the principles of federalism, that have not changed. We have not preempted the states from the critical role they play in providing for consumer welfare and antitrust and consumer protection enforcement. I don't see that changing in my lifetime.
Thank you, Bob.
Thank you very much, Laurel. Appreciate it very much.